In some cases, there is a possibility for the winner or obligor of a case to cancel enforcement proceedings opened against them in the case in which they are involved. The execution law includes several sections and conditions that allow for the cancellation of enforcement proceedings taken against the debtor or creditor in certain cases and depending on the circumstances. In most cases and situations, a request for cancellation of enforcement proceedings will be submitted on the part of the debtor, and the registrar of execution or the court are the competent bodies that may discuss the matter and decide whether to accede to the request at their discretion. It is possible to file a request for the cancellation of a specific proceeding from all the proceedings taken against the debtor, or alternatively to file a comprehensive request for the cancellation of all proceedings against the debtor. How is the procedure for rescinding enforcement proceedings conducted? A debtor who wishes to apply for the cancellation of their enforcement proceedings may do so by submitting an orderly and reasoned application to the Registry of Execution, who may under certain conditions and circumstances accept and accede to the application. The registry is then required to select and mark the particular procedure that the debtor is interested in and wants to cancel, and to indicate the circumstances that justify the request for cancellation. The Registry of Execution is obliged to accede to the winner's request automatically, without exercising discretion, and to order the proceedings to be cancelled. Ways to cancel enforcement proceedings. In principle, there are 5 ways in which an execution procedure can be undone. Repayment of the debt. This is the best and most effective way to eliminate foreclosures and enforcement proceedings. Debt repayment means repayment of the debt in full directly to the Execution Bureau. In any case where you have the option to pay and repay the debt, you can go to the Execution Bureau, where your case is managed, and pay it off in a simple manner immediately. Another option for settling the debt payment is via the internet, by phone or by credit card. Reaching a debt settlement with the winner. If you do not have the ability and possibility to repay the debt in a case that is opened and is being conducted against you in execution, in some cases, you can cancel the procedure by reaching an agreement with the winners in a debt settlement procedure. The winners are the ones who actually conduct the enforcement proceedings, and they can request cancellation of the proceedings conducted against the debtor. Reaching a debt settlement with the winner is made possible by opening negotiations with him in execution, or by submitting an application to spread your debt into payments, which will make it easier for you to meet the repayment payments. In any case, it is worthwhile and essential to enlist the professional services of an expert execution lawyer who is knowledgeable in a debt settlement procedure, who can negotiate in your favor so that you can exhaust and exercise your full rights. Filing an application to open insolvency and economic rehabilitation proceedings. If you have reached a point where you have accumulated heavy debts and are unable to repay them, you may consider filing an execution order to initiate an insolvency proceeding. Insolvency is a procedure that is designed and suitable for debtors who meet certain threshold conditions that appear in the updated and new insolvency law, and who wish to settle their debt and obtain a dismissal order on the way to writing off the balance of their debts at the end of the procedure. Upon receipt of a request to initiate proceedings, the Registrar of Execution will issue a reserved order to initiate insolvency proceedings. This procedure will result in the freezing of all collection proceedings that have already been taken against the debtor, previously including foreclosure actions.
Application for a payment order. In addition to initiating insolvency proceedings, an application can be made for the issuance of a payment order for the spread of debts, depending on the debtor's financial situation and ability. In the next stage, a petition can be filed for cancellation of foreclosures imposed on the debtor in order to obtain a payment order. The debtor is required to fill out relevant certificates and an economic examination questionnaire designed to prove to the execution registrar that indeed the debtor is unable to meet his obligations and repayment, and therefore, debt repayment is essential and required. The debt can be spread over 2 periods of repayment only, according to Section 7A of the law. Deployment of the debt for 3 years if the amount of the debt is less than NIS 100,000. Deployment of the debt for 4 years if the amount of the debt exceeds NIS 100,000. However, as a result of the corona crisis, the legislation has recently been temporarily amended so that there are execution cases in which the debts will be spread over longer periods of time, and this is subject to and at the discretion of the Registrar of Execution. Procedure for filing an application for cancellation of the execution procedure. There is an option to apply to the Israeli Registry of Execution to cancel the execution procedure on the grounds that the imposition of the lien severely harms you as debtors, for example, significant damage and impairment of your ability to work and your livelihood. The application must be submitted by sending a Form 214 in which you must fill in your personal details, mark in Section 3, Remedies, the option, Other reason, and attach to the form an application relevant and appropriate reasons. In the form in Section 4, you must select and mark the option, cancellation of the particular procedure that you want to cancel, and in Section 7 you must also add details on the subject. It is also recommended to attach evidence and certificates that substantiate and support the cause of action for the cancellation of the execution procedure. Once the application for cancellation of a procedure or proceedings has been filed, the Registry of Execution will examine the application thoroughly and professionally and give the winner an opportunity to give his response to the application. The debtor must send the application by registered mail to the winner in the case, and the winner will be given a period of 1 week to give his response to the application.
Relevant reasons for requesting cancellation of enforcement proceedings. Among the reasons that can be listed in the application for cancellation of law enforcement proceedings, these are the main reasons. Cancellation of foreclosure of a vehicle, if the vehicle is used for work purposes or for the mobility of a person with a disability, and therefore, the foreclosure procedure of the vehicle can severely damage the debtor's income and daily functioning. Consolidation of cases, in cases where the debtor is bound by a monthly payment order in the process of consolidation of cases in the amount of 3%, and therefore it is appropriate to cancel the foreclosure proceedings since the debt is expected to be repaid within a reasonable time. Defects and failures in the execution case, situations in which the debtor never received a warning or caution before initiating proceedings in the OTSL proceedings, or any mistakes were made throughout the management of the case. Removal of salary foreclosure, a situation in which foreclosure of the debtor's salary will prevent him and his family members from living with dignity, and he deviates from the provisions of the wage protection law as they appear in Section 8. Cancellation of foreclosure of the debtor's bank account. If foreclosure of the debtor's bank account will cause him serious and ongoing damage to third parties, such as suppliers of a business, that may lead to a significant increase in the volume of his debts and impair the debtor's ability to repay his debts to the winners. Cancellation of foreclosure on property. If a foreclosure has been imposed on inventory of products in a manner and in a way that does not allow the debtor to continue running his business, then it is possible to request cancellation of the foreclosure on this ground. Even when property on which a foreclosure has been imposed is in the debtor's home, but is owned by another person living in his home, it is possible to request the revocation of the foreclosure.
How to file a request for cancellation of enforcement proceedings. The request for cancellation of enforcement proceedings can be filed in 4 ways. Manual submission of the appropriate and designated form for the application and of all references required by the Bureau of Execution where the case is being handled. Online submission of the form and the required references by sending an email to the email address of the issuing bureau where the debtor's file is managed. Submit an online application on the execution website. Filing an application through a lawyer for cancellation of the procedure by an attorney using a system of interlocking tools. Cancellation of an execution proceeding can be done in several ways, but in all cases, it should be noted that it is important and better to get guidance and advice from an insolvency and bankruptcy lawyer who is well acquainted with the debtor's case as well as his status and circumstances leading to the proceeding. The legal assistance of an expert lawyer in the field of insolvency and enforcement proceedings is important and helpful, as experience and familiarity with the details of the case has a significant contribution to increase the chances that the request to cancel the enforcement proceedings will be granted.
What types of enforcement proceedings can be dismissed? The head of execution is the professional body and has the authority to decide and declare the cancellation of all proceedings that take place against debtors in the Bureau of Execution or his stay, subject to the receipt of the request for cancellation of proceedings. In other words, the role of the Chief Executing Officer is to examine the official application submitted on behalf of the debtor in relation to the various considerations relating to the debtor's financial situation, the situation of the creditors in the case, and the balance that exists between them. According to the law, the head of the executive branch may rule and order the cancellation of enforcement proceedings taken following and after the issuance of a judgment that has been changed or updated. Execution proceedings that can be applied for cancellation. Declaring a debtor as limited in means. Evacuation procedure. Foreclosure procedure and execution of a bank account. Procedure for removing or foreclosing movables. Cancellation of various restrictions imposed on passports, driver's licenses, and credit cards. A leading and experienced insolvency and execution law firm. If you have given up trying to collect debts that you are entitled to by law, or your debts to others have swelled until they get out of control, it is advisable to contact an experienced insolvency and execution lawyer for advice and legal assistance in the execution and management of the case. The law firm and notary Scheiman Hahn is at your service and will be happy to provide you with a variety of comprehensive and effective legal services that will help you deal with and optimally manage the case opened against you in execution, customized to the circumstances of the case, or reach a convenient arrangement that will allow you to repay the debt and get a full dismissal so that you can embark on a new path and open a new chapter in life. Our firm is considered one of the leading firms in the field of civil law, commercial, real estate, inheritances and wills, enforcement proceedings, and more. Our team of lawyers makes every effort to achieve the best legal outcome for its clients. We will make every effort to provide you with an answer and solution to any problem, answer any question, and manage your execution file in the best and most efficient way.